of us who are familiar with driving cars would know that a red robot means stop. But I don't know how many experienced drivers still drive through red robots, even though they know that a red robot means stop. So the point I'm trying to make, Chairperson, is that let me start by this rhetorical question, Chairperson. So who we are and what do we do? Chairperson, as you know, we are the Parliament of the Republic of South Africa. And our primary functions include making laws, and that finds expression in terms of Section 44 of the Constitution of the Republic of South Africa. We facilitate public participation in the business of Parliament. And of course, that finds expression in Section 59(1), subsection A of the Constitution. We exercise oversight over the executive, and that, of course, finds expression in Section 55(2) of the Constitution of the Republic of South Africa. Chairperson, of course, throughout the presentation, Chairperson, I'll be asking these rhetorical questions, Chair. So, Chairperson, what is oversight? And we say, Chairperson, that parliamentary oversight in terms of our own constitutional scheme is not merely a political opportunity for opposition. It is a constitutionally mandated function. And the reason why we say so, Chairperson, is that if you look at other jurisdictions, for instance, the United Kingdom has an uncodified constitution, and there is no single document that mandates oversight. Instead, the concept of parliamentary oversight relies on long-standing political conventions, historical precedent, and standing orders of the House of Commons. And this also applies in New Zealand, where the mandate for oversight is largely derived from statute and practice rather than a supreme constitutional charter. Chairperson, we say oversight requires scrutinizing and overseeing executive action and any organ of state. And of course, Chairperson, if you go to, this is well captured, Chairperson, in Section 44, subsection 3 of the Constitution. And I'll read from that section, Chairperson, and members will excuse me for that. The National Assembly, because this is a committee of the National Assembly, is elected to represent the people and to ensure government by the people under the Constitution. It does this by choosing the president, by providing a national forum for public consideration of issues, by passing legislation, and by scrutinizing and overseeing executive action. We say, Chairperson, oversight is broader and more flexible than simple accountability. We'll explain that, Chairperson. And of course, we say it refers to the crucial role of legislatures in monitoring and reviewing executive actions. Now, Chairperson, before we deal with the dichotomy between accountability and oversight, if you look at Section 55, subsection 2, Chairperson, of the Constitution, it provides that the National Assembly must provide for mechanisms to ensure that all executive organs of state in the national sphere of government are accountable to it and to maintain oversight of the exercise of national executive authority, including the implementation of legislation and any organ of state. Now, the issue, Chairperson, then is there's a direct correlation between oversight and accountability. And of course, the Constitution in Section 55(2) makes mention of both these concepts. So what is oversight, Chairperson, in a nutshell? As we have said, Chairperson, we've touched on this words. It is a process of monitoring. In other words, you are monitoring, you are observing, you are checking. And of course, the pertinent question is, are you doing what you are supposed to do? And of course, the focus is on prevention, compliance, and real-time guidance. And the action that emanates from that is watching, analyzing, inspecting, and guiding. And of course, it relies very heavily on facts. Whereas on the other hand, accountability is an obligation to answer for for outcomes, decisions, and actions. And the pertinent question for accountability is, what were the results of your actions? And will you take responsibility for them? And of course, the focus is on consequences, justification, and making amends for errors. And the action that emanate from that include explaining, taking ownership, and accepting penalties or rewards. And accountability relies directly on oversight mechanisms to identify who is answerable. If I may make an analogy, Chairperson, I know you are a football fanatic. So we think of the two, Chairperson, as a continuous loop in terms of how they work together. And oversight is the act of watching the game unfold to ensure players follow the rules. And then accountability is the moment a player has to explain their performance, accept responsibility for their mistakes, and accept the final score. So oversight acts as the foundation. It monitors progress and flags issues. And of course, accountability relies on those findings to demand justification and implement improvements. So that's what the dichotomy is about. And when you account, Chair, you are giving an account of actions. It could be on policies or spending. I think I've explained this, Chair. It requires a person to explain and justify decisions or actions against that criteria. Accountability also requires making amends for any fault and taking steps to prevent recurrence. While on the other hand, oversight may entitle Parliament to hold persons accountable, oversight is a broader concept, as I've explained above. So oversight traverses a far wider range of activity than accountability alone. So, Chairperson, we're going to talk about the scope and ambit of parliamentary oversight. And the key question there is, how far can Parliament take its constitutionally mandated oversight function? And one inherent limit, Chairperson, is the doctrine of separation of powers. And the doctrine allocates specific functions to distinct institutions with defined jurisdiction. It separates three branches, which is the legislature, parliament, the executive, and the judiciary. And the doctrine of separation of powers means ordinarily that if one of the three branches of government is responsible for the enactment of rules of law, that body shall not also be charged with their execution or with judicial decision about them. The same will be said of the executive authority. It is not supposed to enact law or to administer justice, and the judicial authority should not enact or execute laws. So each branch should not perform the functions reserved for another branch. And we say, Chair, it would conflict with the doctrine if Parliament became a law enforcement or investigatory body. Chairperson, I've discussed this issue before, and of course, I know members of the committee, some of them, they've differed with me. But if you look at Chapter 4 of the Constitution, Chairperson, which deals, which is from Section 42 to Section 82, which deals with Parliament, you can read it line by line, Chairperson, that chapter. You will never find the word investigate in that chapter. Nothing. It's not there. The word investigate only appears in the Constitution 12 times. It appears twice when one is dealing with the functions of the public protector, which is a Chapter 9 institution. It also appears twice when one is dealing with the South African Human Rights Commission. No, I'm sorry, once, Chairperson. And then, of course, once when one is dealing with the functions for the Commission for Protection of Rights of Cultural, Religious, and Linguistic Communities. It also appears once when one reads the functions of the Commission for Gender Equality. And of course, it appears 4 times on Chapter 10 on the powers and functions of the Public Service Commission. And it also appears 3 times on Section 11, which deals with security services, particularly the police. So, separation of powers, limits, and oversight. So, Chairperson, we say that a complete separation of powers is not fully possible in theory or practice. And I think, Chairperson, the clearest example of overlapping power is delegated legislation. While the legislature is theoretically the sole body responsible for creating laws, in practice, parliaments pass enabling acts that give the executive branch, which is government ministers and departments, the authority to create binding regulations and rules. So we talk here, Chair, of executive lawmaking. And we know the executive branch passes thousands of highly detailed regulations that carry the weight or the full weight of law, thereby performing a legislative function. Here, Chair, we're merely saying that our jurisprudence seems to be authoritative on the fact that the primary responsibility of a court is not to make decisions reserved for or within the domain of other branches of government, but rather to ensure that the concerned branches of government exercise their authority within the bounds of the Constitution. Here, Chair, we deal broadly with Parliament's control over the executive. And we say that control means influence, not direct power. It means advice, not command. It means criticism, not obstruction. It means scrutiny, not initiation. And it means publicity, not secrecy. Here, Chair, we deal with one strand of accountability, which is explanatory accountability. And this is where the executive is required to give reasons and explanations for their action as the Constitution demands. And we say the bulk of Parliament's oversight work falls under this category. And this is usually referred to as soft accountability. And it builds on the culture of justification, which permeates our constitutional scheme. And of course, that culture, Chair, refers to things like sources of authority or sources of power. And we say conventionally, this takes the form of oral and written questions, debates, parliamentary inquiries, which is the territory we're in, and the resultant reports. And this is another strand, Chair, which is amendatory accountability. And here we say the obligation to redress grievances by remedying defects in policy or legislation. And we say this deals with Parliament's ability to alter the executive behavior through sanctions and consequence management. And this is usually referred to as hard accountability, which of course, many pundits say it is better handled or suited to the judiciary. And this is consistent with the doctrine of separation of powers. Chair, I think we've said there is no universal model of separation of powers. However, the principle of separation of powers recognizes the functional independence of branches of government and prevents the branches of government from usurping power from one another. And we say Parliament should not usurp the role of prosecutorial and investigatory bodies. And we say doing so would conflict with Parliament's core mandate, which is to make, amend, and repeal laws. Sorry for this. So, Chairperson, as we conclude, we talk about striking the balance the power to execute and enforce laws must remain with the executive. We say the doctrine of separation of powers is about striking the necessary balance between the three branches of government. We say Parliament's oversight role is constitutionally mandated, very powerful, but bounded. And we say explanatory accountability is Parliament's primary oversight tool. And we say amendatory accountability is more appropriately exercised by the judiciary. And Parliament must remain focused on its core constitutional mandate. This reaffirms our terms of reference, Chair, which set out the legal framework within which the committee operates, particularly paragraph 2.19, which provides that the committee may refer sorry for that, Chair. It's just that this case. So we say particularly paragraph 2.19, which provides that the committee may refer matters to the appropriate authorities without attempting to determine criminal liability, thereby respecting the separation of powers amongst the branches of government. Additionally, Chair, we say the relevant portfolio committees of Parliament must track and report on the implementation of the findings and recommendations of the National Assembly. Chairperson, one aspect which also we need to address is the issue of I'm not sure whether I'll be speaking. I'll be saying what Nicolette or my colleague Christine are going to talk about. Just on the technical aspects of the committee reports, Chairperson, we say that the committee reports and recommendations are scanned to ensure that the recommendations that the National Assembly adopts conform with the Constitution, the principle of separation of powers, the authority of national executive, and its accountability to the National Assembly. And we say, Chairperson, the committee recommendations need to be motivated. A committee report should provide the House with enough information to enable the House to take a decision about whether it wishes to adopt the recommendations contained in the committee report. And Chairperson will also address you on the recommendations and where should they be pitched. And we say, as a general principle, committees should engage in oversight matters at a national policy level rather than an operational level. Where operational problems are identified by a committee, they should be linked to broader policy issues. We also say, Chairperson, a recommendation contained in a committee report should, as far as possible, steer clear of phrasing that instructs rather than requests or urges. And by following this approach, not only is the principle of separation of powers respected, but it also allows for a situation where additional explanations, alternatives can be brought to the fore by the executive. Parliament can only instruct by way of legislation. And of course, Chair, on the issue of language usage and structure, we say where language use is poor and the report is unstructured, this will reflect badly on the image, not necessarily of the committee, but of the National Assembly. And we say reference in a committee report, for example, reference in a committee report to a certain nationality as thugs or drug lords is a negative reflection on a group of people. And we say the status of the House is indeed affected if it adopts a report which is poorly worded or vague. In respect of reference to public officials, individuals, and organizations by name, we say in view of the impact of references by name to individuals and organizations, discretion is required when drafting a committee report. Also, when criticizing public officials, it should always be borne in mind that the minister is finally responsible for actions of his or her own department. And Chairperson, lastly, on the time limits for responses contained in recommendations. We say recommendations that require written responses to be submitted back to Parliament or National Assembly usually do not take into consideration that the committee's report may not be considered immediately after the committee has adopted and published its report due to other matters that the National Assembly should consider. Where a committee would require responses to be submitted to the recommendations it makes, the committee could frame the recommendations. For example, a report be submitted to the National Assembly 6 months after the adoption of the report. Chairperson, I will leave the stage for now and allow my colleagues, either Nicolette or Chris, to chip in. Thanks, Chairperson.
Thank you so much, Mr. Tejana. Can we allow Nicolette to come in?
Thank you. Thank you very much, Chair and honourable members. Now, Chair, having now considered the constitutional and legal framework within which the committee must operate, the next presentation by Christine turns to the practical question on how the evidentiary record has been organized and how the preliminary draft report has been structured to support members in undertaking their deliberations. Chair, with that, I kindly hand over to Christine to take members through the structure and methodology of the preliminary draft report.
Good evening. I'm sorry. Can you also you can see my screen? Nicolette, can you see the screen?
I'm sorry, Chris. Yes.
Yes, we can see that.
And can you see? I'm just trying to. Oh, that's okay. No, sorry. I always get very confused. Now I don't have the screen in front of me. Oh dear. Okay. So I'm just going to get to slideshow. It doesn't want to do that. Okay. Yeah. All right. Nicolette, I'm sorry, I'm really struggling here to get it to go to move.
Mhm.
What am I doing wrong?
Sorry, Chris. Would you mind me flighting the presentation?
Yeah, that would make it a lot easier for me. I would really appreciate that. Thank you.
Cool.
Okay, I'm gonna stop sharing him. Nicolette?
Sorry, I'm coming. I'm getting there. Apologies, members. Here we are.
Oh, brilliant. Okay. Yeah, as I say, good evening. I don't know what it is about presentations and on Zoom. and slideshows, I always end up feeling like very lost. I don't understand why, because it's not the first time I've had to do this. This is just it's a very quick, it's an overview of the structure of the preliminary draft report that has been circulated to members. Nick, can you go to the next slide? Thank you. Before I start, I do have quite a soft voice, and when I'm nervous, it drops. And I also start talking really fast. So if you can't follow me or I start talking too fast, please just stop me and let me know. So just to start off, introductory remarks are just to say that this presentation is intended to set out the preliminary draft report's architecture. And you'll see everywhere there are comments there. We highlight preliminary and draft. We are well aware, we're acutely aware that this draft report has not, that as members, although it was circulated, you have not deliberated or okayed anything. The intention here was to put together, largely because of the time constraints, a working document that contained a detailed, structured set of proposals that would assist members as they move into their deliberations and final positions. Next slide, Nick. So just something quickly about the nature of the draft report. It is what it does. It's framed as a parliamentary oversight report. I know that we, in terms of the mandate, they use the words inquire and so on, but it's an inquiry in the sense that it's an oversight inquiry, and I'll just get to that. So it's framed as a parliamentary oversight report which assesses the evidence from an oversight perspective. It identifies governance failures and accountability gaps, and it proposes reforms and follow-up mechanisms. Importantly, the report does not treat every allegation as proven. It does not make any direct findings of criminal guilt or liability, and it doesn't otherwise seek to replace the work or the responsibility or the role of competent investigative and adjudicatory bodies such as SAPS, the Hawks, IPID, IDAC, SIU, the courts, etc. In terms of the proposed structure, the draft report moves from process to evidence, then to conclusions and remedies. And it proposes 15 substantive sections. So sections 1 to 11 contain the details of and or describes the committee's mandate and process. I'll say a little bit more about this later on, and Nick will also have a bit more to say in the presentation that follows. Section 12 describes the evidence that was presented by each of the witnesses testifying before the committee, and includes the testimony of academic, expert, and public participation witnesses who appeared before the committee, as well as the President's written statement. Section 13 assesses the evidence. Sections 14 and 15 contain preliminary findings and recommendations. At present, these are intentionally, because we were working within the realm that we felt comfortable to do, restricted to governance and institutional related concerns. So they're more of a technical nature. And then there are acknowledgements, and then there are annexures that would need to be added to the document, but these are still to be determined. But one of them would be, for example, the terms of reference. In terms of sections 1 to 11, this is just a description of the committee's process. So it details the details, well, the sections under that contain the introduction, the background and context. It sets out who is a member of the committee, the mandate and terms of reference, the legal framework, the methodology and process, the limitations. It notes parallel processes, the Matt Langer Commission. It recaps preliminary and interlocutory matters. Those are things that we had to discuss as a committee in between, about, how one of the things would be subpoenaing witnesses. And then public participation, that's because we have a separate public participation report. This little section is at a very high level. And then the final section 11 sets out the witnesses, the names, and the stations of the witnesses who appeared before the committee. And the next one, so then we move to the evidentiary overview. And again, just to stress that it summarizes the evidentiary record by witness, but it is intentionally descriptive. It does not, or it avoids assessing that evidence or making any inferences. And then, just given the volume and the complexity of the evidence that is before the committee, it was useful to organize it around 6. I've called them evidentiary strands that reflect the major areas of inquiry identified in the terms of reference and provide a consistent structural framework for recording the evidence across a wide range of witnesses. So once you structure that, once you structure the evidence, you can then start putting similar things together, and then you can analyze it and assess it. It's very difficult to do that when it's all over the place, it's ad hoc and piecemeal. Next slide. So just to quickly go through the evidentiary strands. The evidentiary strand A addresses governance, executive authority, and leadership conduct. Strand B looks at the PKTT's mandate, its status and operational performance. Strand C addresses crime intelligence, stability, and intelligence-led policing. Strand D looks at corruption allegations, conflicts of interest, and procurement practices. Strand E, organized crime allegations and institutional integrity concerns. And Strand F is your interagency interaction, evidence handling, and procedural integrity. So just to explain, I think I've already started doing this, explaining that there is a relationship between the strands in the terms of reference. It's referenced, each evidentiary strand is cross-referenced to one or more provisions of the terms of reference. That in that sense, we've looked at the scope, the section under the terms of reference that deals with the scope of the inquiry. It serves to connect the raw evidentiary material, those are the witness testimony, the affidavits and documents, with the thematic assessment and findings that follow. The approach helps to make sure that we cover every required issue in an orderly and structured way, shows a clear path from evidence to analysis, and avoids reviewing the evidence in a piecemeal or one person at a time way. Section 13 moves to assessment and analysis of the evidence. It adopts an analytical framework, which is structured around 7 themes that are aligned to the terms of reference and to the mandate. These themes are evaluative. They assess what the cumulative evidence, so the evidence put together, discloses about legality, governance, institutional integrity, accountability, and systemic risk. The analytical framework does not replicate the evidentiary structure. It would have been nice if we could have said, that the evidentiary strains were exactly the same as the thematic themes. But this is the reason why is that certain evidentiary strands inform more than one analytical theme, while some analytical themes draw on evidence across multiple strands. So the themes are, theme 1 is your governance, executive authority, and leadership accountability. The theme 2 is your operational effectiveness, your task team governance, and case management. Theme 3 looks at your crime intelligence, instability, I suppose we could say stability again here, and intelligence-led policing. So you can see they're quite similar. Theme 4 is corruption risk, conflicts of interest, and procurement integrity. Theme 5 is organized crime, institutional vulnerability, and systemic risk. And theme 6 is your interagency coordination, evidentiary integrity, and process compliance. Theme 7 is your one around public trust, institutional credibility, and national security implications. And again, to just stress that each theme is aligned to the terms of reference. Under each of the themes in that section, the discussion includes includes a discussion of the relevance of the theme to the terms of reference. It sets out the related or relevant evidence to the theme. It notes the evidentiary strengths and weaknesses, and it has an assessment of the evidence. Sections 14 and sorry, something happened here. Sections 14 and 15, it should read at the top, and deal with the findings and the recommendations. Both sections are preliminary. They're subject to consideration and assessment of the record. The findings in section 14 are framed as governance and/or institutional findings and are grounded in the evidentiary record as assessed. And the recommendations in section 15 are aimed at practical oversight and reform. Again, I just want to stress that these are preliminary. They are largely technical in nature. They are mostly framed around governance and institutional concerns. And you will see that the briefing paper that Nicolette, Annie, and Mzi prepared around governance issues has played a large role in this as well. Nick, the next slide. So a possible approach to deliberations, and these are, I'm just throwing out some ideas. Obviously the committee can consider it. So we're putting the preliminary report before you for consideration, deliberation, and amendment. And hopefully at some stage you will be reasonably happy with the final product and sign off. So a practical approach to working through the draft might consider the following. The first part, the sections 1 to 11, the mandate and the process. So you would ask yourself whether you're happy with the way that these have been reflected. Is there anything you wanted added, something you feel that should be removed or amended? Then you'd ask yourself, and the second part is, is this evidentiary overview? Is this a fair summary of the evidence? Is there stuff that you would want included or emphasized or added or so on? Has there been anything that's critical that's been overlooked? Then then assessment that really forms the body of your deliberations, and findings. You can make, then the next part will be findings. Again, these will be supported by the evidence, and recommendations that are clear and implementable. Thank you, Nick. Is that the last slide? So thank you, members. That was my last slide, and I hope that it makes sense. Yep, and Nick, I'm going to hand over to you as our facilitator of the work of this part of the workshop. Thank you, Chair.
Thank you. Thank you so much. Are you Miss Van Zyl or Miss House?
Chair, sorry, I'm Miss Van Zyl House. It's a double barrel.
Okay, thank you so much, Miss Van Zyl House, because I heard Andy saying, oh, Mr. Techana, I heard Mr. Techana saying Miss House, and I thought maybe there was something wrong that I was saying. So we have to put it on record, and we must apologize for the many instances that we would have inappropriately addressed you. At least today we know that you are Miss Van Zyl House. Okay, thank you so much for the presentation. Before I rotate to hear the inputs and comments of my members, is there anything that the presenters would want to say? Mr. Techana, are you fine?
No, I'm fine.
Okay, Ms. Van Zyl House.
Sorry, Chair, to interject. Chair, I just want to make have clarity. Would we now, as you indicated, go into deliberations or discussions, and then I will come in with more detail on sections 1 to 11?
After the comments, no?
Okay, thank you, Chair.
Or did you want? Okay, no, let me allow you to say it now so that when we go to deliberations, members can deal with everything.
Okay, thank you, Chair. Chair and members, as Christine stated just now in her presentation, sections 1 to 11 deal primarily with the committee's mandate, legal framework, methodology, procedural history, and related contextual matters. They essentially establish the foundation upon which the remainder of the report is built. Now, unlike the evidentiary assessment findings and recommendations that follow, sections 1 to 11 are not intended to be really yeah, something, a contentious area of the report. It's not contentious in nature. The primary focus is to ensure that the report accurately records the committee's establishment mandate, processes, and proceedings. Chair, if I'm allowed, I would want to quickly just scroll through the first 11 sections, and thereafter we can take it through or forward. But the idea here is, Chairperson and members, that once you have these sections, it will be appreciated if members can work through it after the meeting or when you have time to propose any amendments. And again, it would be really appreciated if this could be submitted in writing to the content team somewhere next week. And this will naturally assist the support team in consolidating members' inputs and incorporating any agreed changes into a revised draft. So, Chair and honorable members, like I said, the intention of the first 11 sections is foundational sections accurately capture the committee's institutional record and provide a sound basis for more substantive deliberations that will follow in relation to the evidentiary assessment findings and recommendations. Chair, so I request whether I am allowed to quickly run through these sections.
Yes, you are allowed.
So, Chair, honorable members, what you have on the screen is the preliminary first part of the report. Just quickly going through, we have the introduction, and this really centers around the resolution that was adopted by the National Assembly, and then going on to the conducting of the inquiry in terms of its terms of reference. I'm not going to read through everything, Chair and members. I'm just giving an overview of what is to be expected when members consider these sections. We are saying here, or indicating that the committee has several, don't want to say delays, but delays in starting, but that the committee remained focused on fulfilling its mandate in a manner that was thorough, balanced, and consistent. with its constitutional obligations. The section 2 and then provides the background and context to the inquiry, and these it's really also contained in our terms of reference. So, the summary, as we say here, the summary of the allegations in the section serves an explanatory and contextual purpose, only and should not be read as findings or determinations by the committee. Section 3 deals with the committee membership. Just scrolling through and giving, these kinds of details when the first meeting of the committee commenced, and that the chair was in fact elected. Section 4 deals with the mandate in terms of reference, and the members are very familiar with the content of our terms of reference. So I'm just going to scroll very quickly past it. And then we are having here a relationship between the mandate of the committee and the terms of reference. So also, we are just giving the objectives as contained in the terms of reference, and then also the scope of the inquiry. Under section 4 is also the nature of the committee of the inquiry, and saying that it is neither judicial nor quasi-judicial, but rather informed by Parliament's constitutionally mandated oversight role. So it was conducted in an inquisitorial oversight process aimed at gathering information and assessing evidence, to which the principle of rationality, legality, and procedural fairness applied. It also contains just a short section on the powers of the committee when in carrying out its mandate. We also have the safeguards included in the terms of reference. Just a very short section on public participation. And as Christine stated, that there is a separate public participation report, and that is why it's not really substantively covered in the section 4.8. We also have the function of the terms of reference, and just the function really in terms of the terms of reference giving practical effect to the mandate of the committee. Section 5 deals with the legal framework against which the committee operated. Again, I'm not going to go through this really. It is also contained in our terms of reference, and members are quite familiar with the powers of Parliament and the legal framework. As Andile pointed out, also we have here the separation of powers and limits of parliamentary inquiries. It also deals with the statutory powers and safeguards, the rules of the National Assembly, and the application to the committee's work. Section 6 deals with the methodology and process adopted by the committee. Again, it deals with the mandate and terms of reference. Like Christine indicated, the terms of reference will be attached, amongst others, as annexures upon the determination of the committee. Also in section 6 is in the objectives of the committee. Again, the scope of the committee in a bit more detail. The time frame and duration of the inquiry. It's just highlighting the expected completion date of the ad hoc committee. Section 6.5 deals with the conduct of the committee, stating here really what process was followed and the appointment of the evidence leader. 6.6 deals with the witness selection and sequencing. We're stating here that the General Mkhwanazi formed the foundation of the committee and that he appeared before the committee as, like I say, the foundation. We are touching here on the attendance and venue of the hearings, in that the committee resolved to conduct the proceedings primarily within the parliamentary precinct. It also states here that the committee did conduct a hearing in Gauteng province. It's just a short section detailing the security measures that was implemented during the duration of the ad hoc committee. Section 6.9 deals with the handling of classified and sensitive information, and really, centers along the Joint Standing Committee on Intelligence and the access to information, and that it was prescribed the conditions and procedures. Section 7 deals with the limitations of the committee. Section 7.3 relates to the institutional limits, just again stating that it is not a judicial or quasi-judicial body. 7.4 deals with the evidentiary limits. As Christine indicated previously or in her presentation, we also deal with the parallel processes, and like above, the classified and sensitive information as a limitation to the inquiry. Also, under limitations, we are having time and resource constraints. Section 8 deals more detailed with the parallel processes in the establishment of the Mkhwanazi Commission of Inquiry. And just also stating actually the difference between the Mkhwanazi Commission and the ad hoc committee. Christine also referred to the preliminary and interlocutory matters. And here we have the participation of alternate members that was discussed. Issues relating to recusal and apprehension of bias. And the committee also addressed isolated incidents relating to threats and interference with witnesses, requests for virtual appearances, and the conduct of proceedings by certain witnesses. And also dealing with the invitation to the Inspector General of Intelligence that he did not appear before the committee. Section 10 deals with the public participation, and this elaborates a bit more compared to the previous section. And then section 11, last section in this presentation, deals with the witnesses appearing before the committee. And like we say here, it lists the witnesses in the order that they appeared. So that's just their names, designation, and dates of appearance. In section 11.6, we deal with witnesses that was unable to appear. And here we have the two public participation witnesses. The first that was unable to give oral evidence due to a medical condition affecting his ability to speak. And I just want to stress here, honorable members, that his written testimony or his written statement, it is captured in the evidentiary overview that we circulated. And then the other person that was subjected, as members can recall, to procedural considerations regarding relating to security clearance. And then we also have the written evidence from the Honourable President. Honourable Chair, Honourable Members, this concludes just a run-through of the first 11 sections. And as indicated previously, it will be really appreciated if members could give input on these sections, preferably in writing by next week. Thank you, Honourable Chair. I submit.
Okay. Honorable members, I hope that you understand the presentation that Ms. Van Zyl has made. Number one, we received presentations here on the principles that we should apply when we will be dealing with the evidentiary overview, which I think were straightforward in the presentations, enriching the understanding of members with those questions that Mr. Tejana repeatedly asked about who we are, what are our main functions as a parliament. And then secondly, there is a proposal that has been tabled before us by Ms. Van Zyl on the first part of the report, which she says from her observation, this is a self-explanatory part that is not contentious, as in the main it's just about a record of proceedings or some of the matters that would have previously appeared before us, and we have agreed on those, like the terms of reference, introduction and background, attendance, list of witnesses, up to the last part in section 11 that she has run through here. And her submission is that instead of coming to sit in a meeting and go through those paragraph by paragraph or page by page, members could just make submissions, and then their submissions will be factored into those sections from 1 to 11, if I'm representing you correctly, Ms. Van Zyl.
Perfect, Jay. Thank you very much.
These are the sections of the draft report of the committee, isn't it?
Yes, Jay.
Thank you so much. And okay, Mr. Tejana.
Yes, Chair. No, I was just going to say, Chair, perhaps because if you look at today's agenda, I'm not sure if members saw that tomorrow and Friday we will be dealing with the evidentiary overview deliberations.
Yeah, I wanted to come. I wanted you to talk to that part so that members know the expectations for tomorrow and Friday. Remember, there is an approach that we agreed on. What is it that we are dealing with tomorrow? Before I circulate, before I rotate for them to give their inputs, so that we deal with all these matters at once. When we leave this meeting, like I said last night, each one of us must leave here knowing that when we gather again tomorrow, we will be dealing with this section in the evidentiary overview.
Chair, I'll leave that to Ms. Van Zyl. Thanks.
Okay.
Thank you, Honourable Chair, honourable members. If I can just quickly say, so from tomorrow through the end of next week, the committee will really begin its consideration and deliberations on the evidentiary record. Members have been provided with the committee's draft evidentiary overview, organized under the evidentiary strands, as well as the evidentiary overview prepared by the evidence leader. At the end of next week on the 19th of June, deliberations are really scheduled to be concluded and then written up by the content team thereafter. It is anticipated that the preliminary draft will be circulated to members on the 22nd of June and then adoption is scheduled for the 24th of June, and thereafter it will be circulated to affected persons for the right of reply. Thank you, Chair.
Okay. Thank you so much. I'm now going to, maybe even before I rotate for inputs and comments, let me check with the members if there are questions. I will rotate, starting with the African National Congress. Are there any questions on the presentations that have been made here?
Thank you very much, Honorable Chairperson, and let me also thank the team for the work that has gone into this, as well as the presentations that have been delivered here this evening. Chair, to be honest, speaking for myself, it is a workshop, so I suppose all of us are speaking, trying to clarify certain things. But speaking for myself, I'm extremely confused. Now, I know that in the meeting before last, there was an explanation that was given with regards to why 3 reports. So there was one that was called a briefing document. There was one, which I think is this one, which is the draft preliminary report. And then I think there was one, which is the report of the evidence leaders. Can I request that that matter is just clarified again, Honorable Chairperson? Which one are we taking to the National Assembly? Or is there an intention to put them together at some point? I think that is still not clear to me, at least. And then the second question, because you said you want only questions right now. The second question is just what Mr. Tekiana has said now. I think I'm even getting confused by terminology. The evidentiary overview, is that different from the assessment of evidence? I have taken them to be two separate concepts, where the evidentiary overview is basically a record of what would have been put forward to us as evidence. Then the assessment is the one that begins to analyze the evidence, raise inconsistencies if there's any, and ultimately leads to recommendations. Now we've got two sets of evidentiary overviews, if I am understanding correctly. If I'm not, can I be clarified on the difference between the two evidentiary overviews contained in these two reports? And then finally, Chair, the last question. Now, Mr. Tekiana, I think it was just now, or Ms. Van Zyl-Groos, apologies. I think my brain is just bursting now. They indicate that we're going to be discussing the evidentiary overview for the next 2 days, and then sets out a timeline by 19th of June, where we would have to now send out these reports. How does that fit into what was said earlier, that political parties would be given an opportunity to go and make written submissions on what is before us? Or are we saying that it's only section 1 to 11 that we must make written submissions on, and then they will only be taking the evidentiary overview? Does it include the assessment of evidence and the recommendations as part of those discussions? So, Chair, yeah, those are just my questions. I think I just need clarity on this process again. Thank you so much.
Okay, can I check if we still have a person or a member from the ANC who will want to ask a question? Or was that only you?
Covered.
Okay. I'm going to allow them to respond, and then we'll go to the MKP. But even before they do that, honorable members, we have 3 reports. The first that they gave us was what they call briefing notes, which helps members to establish an understanding of the proceedings from the first day the proceedings started. It's like an enrichment document. And then the second report that we received is the evidentiary overview, even though that was the last report to be received by the committee. So that must be the second, if the reports were going to be ranked in a particular order, it must be the second report. And then the last report is what we call the committee report, which after all these processes, this is the report that we will table in Parliament. And the part that Ms. Van Zyl-Groos was talking to now is the first part from section 1 to section 11 of the draft committee report. Remember, as and when we do work as the committee, the writing of the committee report continues separate from the assessment of the evidence that would have been presented before the committee. I think what they're trying to be proactive to say, in the meantime, when you will be busy considering the evidentiary overview, if there is any chance that you can make submissions on this part, which we think is not a contentious part, to help us to continue refining that report, it's okay. And then, so from tomorrow, we will be dealing with the evidentiary overview. Members must satisfy themselves that the overview that has been made covers all the proceedings that happened before the committee. And I think the question that you ask, whether there may be, I think it's a decision we made previously, that if members feel that there could have been some aspects in the evidentiary overview that are missing. For instance, there are other witnesses who would have appeared before the committee, and the evidentiary overview says nothing about those witnesses, even if their evidence does not materially impact on our terms of reference. It is important that such information must be reflected in the report. And you want to know if, as members who are going to have an opportunity to make such recommendations on that evidentiary overview. Yes, I think what causes confusion here, and you are justified in your confusion, because when you speak to more than one report at a time, it may create the confusion that you find yourself in. Let me hand over to Mr. Tejana and Ms. Van Zyl and Ms. Silkstone to make further additions. I hope that I would have tried my best in terms of my understanding, but they can clarify further. Mr. Tejana? Ms. House? Okay.
G, thank you very much. I will try to try and explain, but I think G, you really set it out quite nicely. In terms of the discussion document that was sent by the content team. G, I don't want to say it's a problem, because no, I'm not saying that the evidence leaders evidentiary overview is problematic. Because I really am not. I really am not. What we are trying to get to is that the evidence leader report, he made inferences, inferences about evidence of individuals. Like he made an assessment, if I can call it like that. Now the evidentiary overview that will be contained in the committee's report, it provides a it provides an overview of what the witnesses said, but what they stated in their testimony, not what can be inferred from it. Now that will happen when the committee start to deliberate and assess what the evidence actually say and what the evidence tells us. Chair, I hope that makes it a bit more clearer that the evidence leaders report is basically a refresher. I want to say a refresher of some sort, and that it just gives members really a detailed account of what transpired during our hearings, but that for our committee report, we give a very, very factual account of what the witnesses indicated, and that in the overview that will be contained in the committee's report does not make any findings or inferences of any kind. It's just to report what the witnesses stated. And I don't know if members had an opportunity to consider it, but it is the evidentiary overview in our report of every witness, including public participation. It spans about 200 pages. And so it is really a very well structured, I want to say, to give an indication as to what witnesses testified about in the committee hearings, and then also just to bring structure. That has been, like Christine explained, that it is structured really around what they are saying, but under sub-themes and items directly related to the terms of reference, so that it's not like a bulk summary of the testimony, but that it is slotted into an organizational structure of some sort, and that will really assist when the committee consider the evidence and then assess what the evidence show the committee, and then moving from there, you're translating that into findings and then recommendations. Gee, I hope that gives some more clarity. Christine, if you or Andile want to come in.
I think you covered everything, Nicolette, that I was going to say, just that there is a very deliberate separation between the overview, which is descriptive, it's summarized, it's descriptive, and the assessment. Also, and that's the reasons why, is that you need to be able to say, well, I've come to this kind of conclusion, which, because from the assessment, we go to our findings and make recommendations. So when we get to that kind of that evaluative part of the report, you need to be able to refer back to your evidentiary overview or your evidence and say, this is the basis of my finding. If you're not able to show that, then your findings become, they can be challenged because they're not rational, or they might be rational, but it's not clearly linked. So that's why it's been done that quite deliberate. It's been done deliberately. And also, as Nicolette says, that our summary contains the public participation witnesses, the written statements of witnesses who were scheduled to appear but couldn't, the academic and expert evidence that was placed before the committee, which the evidence leaders haven't addressed. And that is also important because it does also create different narratives that create balance, and it needs to be reflected to ensure that the report is fair. We, as the content team, as the drafters, did not feel comfortable going as far as making inferences around individuals' conduct. That is something that I believe personally falls squarely within the mandate of the committee. And to what we did is we went as Nicolette and the chair also explained, we went as far as we could to make sure that our findings and our recommendations capture the kind of more technical findings that you would make. Obviously they can be tweaked and changed and added and removed as the committee wishes. But whatever comes out of deliberations will be added in the right spot. It will be track changed. You'll be able to see what has been added, what you've agreed to. I don't know if that helps or whether I've muddied the waters, but thank you.
Mr. Tejana?
No, I'm covered.
Okay. The question of Honorable Sangoni still remains. What the explanation she needs is, in simple terms, is to say the evidence leaders have expressed an opinion on the evidence that have been presented before them. And the report of the committee as it stands now doesn't express an opinion. It will only express an opinion after members would have gone through the report of the evidence leaders and decide if they agree with that report or not. And it means if they agree with the report on the recommendations that members will be making in accordance with the terms of reference, they will say ABC in the report of evidence leaders, we agree, and then should be part of the final report of the committee contained under recommendations or whatever manner in which we may want to structure our report, but whatever we agree with, it means has to be incorporated in that report. And then further that she has asked a question. Now that evidence leaders have produced a report, in the final end, when the committee agrees on its report, what becomes the status of the report of the evidence leaders? When the committee submits its report, does it submit that report as a single copy, or does it make attachments to that report and say, we have made this report, but for ease of reference, there are the following other reports indexed as follows. One will be the report of the evidence leaders, or this report is part of the heritage of Parliament. It goes to the library. Anybody who wants to read it can go. What becomes the status of that report? The committee report, I believe everybody understands, but she wants to know what becomes the status of the report of the evidence leaders.
Chief, I can go in.
Yes, yes.
And Chief, honorable members, the short and long of the story is that the evidence leaders report, it provides quite detailed information and a recap of what evidence was placed and what deliberations were had by the committee. However, the evidence leaders report is not structured or written in a parliamentary fashion or way. So it's very difficult to say because like the committee can decide, but the manner in which it is written, parliamentary, is problematic because it makes inferences and assessment of findings and assessments on individual people, which is problematic, and I think it's the only way I can really explain it, because, and it's up to the committee. In my understanding, it should not be from any part of the committee's report that will be tabled in the NA. It is only a tool to be used by the committee in deliberations. But like I say, Jay, yeah, maybe Christine can also come in.
Yes, I was just thinking, I mean, we can think about this because we don't have to make a final decision about how we do this now, but I do think there needs to be, and this would probably go in as an annexure, there needs to be a proper record of all the documents and correspondence that has come to the committee and that is before the committee. So it certainly should be included in that index. Whether we wanted to include it as an annexure in its totality as an annexure to the report, that's something that we can decide at a later stage. But at the moment, it's very comprehensive, and except for those witnesses that it doesn't have, and it will be a very useful tool when the committee deliberates. But as the chair put it very nicely, it is an opinion, so it does need to be deliberated on. Thank you.
Okay, Honorable Sangweni, are you covered?
Yes, Honorable Chair, and just so that there's no misunderstanding. So what I'm hearing is that tomorrow, when we do the evidentiary overview, we are basing it on the draft committee report as prepared by Parliament. So we may have wasted a bit of time, excuse me saying so, going through the record, the evidentiary overview that was prepared by the evidence leader. That's fine. Then when it comes to the assessment of evidence as well as the recommendations, we will then utilize the evidence leader's opinion, which I believe that they were entitled to because we did call them as legal counsel with the intention that they would give advice. We will use that as a basis, read together with the recommendations that are founded in the committee report as prepared by parliamentary staff, and anything that we want from the evidence leaders report, we will affirm in the committee report, but our primary document that we are working on is the committee report that sections 1 to 11 have now been presented to us, and tomorrow we will be dealing with section 12, I believe, and then later on, I suppose, we'll then go into sections 13, I'm not sure if it's 13 up to 14, and we can make our additions there. That's how I understand it, Chair, but I don't want to derail your meeting. Thank you very much, Chair.
No, you are very, very relevant. I think the part that you say, let's have Ms. House confirming it, that is exactly what you are saying. Is that so, Ms. Van Zyl House?
No, it is not. It's not completely what we are suggesting. The evidence leaders report is a very, very important document for the committee. It really forms the basis of what the committee will be deliberating on. It's a very important tool to just give an overview and quite a detailed overview of the evidence that was presented before the committee. So in terms of what will happen tomorrow and Friday, is really to pick out of the evidence from the evidence leaders and the summaries that was provided by the content team to really inform deliberations on the evidence. So we will not merely be checking whether the evidence leader has captured the evidence well, but Chair, the committee will use the evidence leaders report as a very important tool for deliberation. So, it is very important still that members did go through the report and, and can come to the committee tomorrow and say, this we agree with, this not, and just start to deliberate on the evidence before the committee. And from there, You know, we can start putting together where the members' heads are and what will possibly flow from the evidentiary deliberations, I want to say, just to, I do hope it clarifies it a bit more.
Yeah, if you remember previously what we agreed on, and this is what was said by Honorable Sangoni in the meeting, and when we left with that understanding that maybe instead of us going through the whole report of the evidence leaders, we will go and, because I mean some of the records, there is striking similarities between the record that you have and the record that they would have taken. We can't spend time on the records, but to say let's go and look at where an opinion is expressed, and if there are recommendations, the recommendations they make, or if there is any other aspects that are missing, members can express themselves on those aspects. And then when we are done with because each and every member was going to be given a chance in the meeting to express or make their own submissions on how they would have on the observations they would have made on the report. That was my understanding as the chair. And when such observations have been made, we will then come back to the report of the committee and then go through it on the thematic approach that we have agreed on. I thought that was going to be very useful for us, so that each and every report that is presented before us, it is given due diligence. What is your take on that one? Ms. Van Zyl?
Apologies, Chair. Yes, I think you captured it quite well. Thank you, Chair.
Yeah, because what I want when we leave this meeting, when we come back tomorrow, we must not come back to a meeting which gets stuck because members did not have the same understanding. I want us to clarify everything to say when we leave here tomorrow, I mean, when we come tomorrow, when the meeting opens, the chair is going to allocate all members, each one of them following each other, an opportunity to make their own observations. And if there are submissions to be made, those submissions will be made. One can say, no, I have observed the following, but a written,
as we speak.
a written submission will follow on the rest. Yes, the discussions on the draft report will be informed by the briefing notes that have been circulated with us. Secondly, by the assessment that would have been done by the evidence leaders. Am I correct in that understanding, Ms. Van Zyl?
Yes, Chair. I think that approach will really assist if we can come back tomorrow with that understanding.
Yeah, and then I was done with the ANC. Let me check with the MKP if there are any questions regarding the presentation. And remember, honorable members, I'm still going to rotate later for you to make any comments that you want to make. Now I just want to make sure that all of us are in the same frequency in terms of understanding.
Thank you, Chair.
KP.
Thank you, Chair. You know, yeah, we've been listening for some time this matter after Honorable Sangweni has make some comments as well. You know, I think it's as Mkhwanazi party. I think I must make this submission. You know, understanding that I've read the whole document, both reports, and when you say that the evidence leaders report, and now I'm saying maybe there's a distinction between the committee's report and the evidence leaders report, which that alone for me confuses me. Maybe I haven't heard it well, that there will be an evidence leaders report and there'll be committee's report. I thought it's one report, understanding that there were 3 reports. But let me suffice to say this, Chair, to you. The fact will remain, you know, that there's nothing to send back to the same people that were the subject of this investigation. In other words, when we had witnesses, if you remember what I said in the last 2 witnesses, General Masemula and General Mkhwanazi, I think I remembered very well. But let me not confuse you, Chair. Let me say this. For me, the report seems to be largely a summarized testimony, you know, of the witnesses, rather than the analysis of what exactly transpired when we had all those witnesses before us. Without the evaluation, you know, of the evidence, can we really make a useful findings? I doubt, Chair. I doubt, Chair. You know, just like the Matlanga Commission, it appears that there's a fear to include the NPA in this report and the judiciary in the investigation, even if, although they were both put into question by General Mkhwanazi, because he mentioned those institutions, you know, on the 6th of July on that press conference, that fateful day. For me, the report also seems to be simple, a summarize, or the summarizing of the proposal, which were offered by the witnesses themselves. And South Africans, I mean, South African people, as you know, are waiting for this report. And it may seem that, you know, we are cheating them as Parliament. If you all, what we do is to summarize rather than evaluate this evidence and make our own conclusions. The approach for me of what I've seen seems to be a tiptoeing around the issues, simple to avoid tension within ourselves as a committee, rather than providing South Africans with the tangible findings and the policy proposal. For me, it's a mere repetition of what the evidence, what the evidence says. Well, perhaps I might be too harsh on that, but I have to be very frank that as Mkhwanazi party, we really felt that, you know, this report, as I read it, as I'm saying that I've finished the report, but some of these, not to waste your time and the committee members' time, that we will be dealing with other sections tomorrow. But I just wanted to make those comments, you know, to say.
I wanted to say to you that you are a day ahead of us. It's already Thursday to you. And we are still on Wednesday, because we are going to give you that opportunity tomorrow to give your own assessment. And if you have written submissions that you want to make, you will also tell the meeting what are the submissions that you want to make. But for
Indeed,
now, I wanted to check if you have questions for clarity.
Indeed, Chair. Hence, I'm saying to you, it's unfortunate if it's a piecemeal exercise now. That for me, the fundamental, in fact, the foundation has to be strong itself. Otherwise, the whole house will collapse. Hence, I'm saying that South Africans should not feel like we are cheating them. You know, we need to evaluate it. But anyway, for the sake of progress, let's go ahead and let's see on tomorrow, you know, how far we can go. But indeed, for me and for Mkhwanazi, this is disappointing because we have already, it's a repetition of what we were told by our witnesses. Thank you, Chair.
Okay. Any questions for clarity, Honorable Shongwe?
Yeah, because Chair, sorry, before the Honorable Chongwe, because why I was saying that, because I think Mr. Tenjani said we'll refer other matters to institution because of the separation of power. And in my view, hence we are saying tomorrow we'll go, you know, because for me, Chair, we can't refer this thing to the right. I'll give you an example, to the Hawks, to the NPA, or to the South African Reserve Bank, or to the Public Protector, because those institutions failed us. In fact, they must come and be before us, before we go take the report to Parliament. They must come and account. And remember, Chair, that it's only the President who had a written question, nobody else. And we still need to go deeper into these matters before we submit this report. Thank you, Chair.
Yeah, you are days ahead of us because we are still coming to those moments and days when each and every member will be given an opportunity to express their views on the evidence before us and the recommendations that should be made. Honorable Shongwe, do you have any question for clarity on the presentations made?
Thank you, Chair. Thank you very much, Chair. I think, as you said, Tubabuskosana is a day ahead of all of us. I was going to be 3 weeks ahead. I was going to ask Uguti, when do I get permission of Farabantu Evening? Because Abantu, they deserve even, Chair. Chair, I would just put an input, not a question, because tomorrow you said we're meeting.
Yeah, I'm still going to rotate for inputs. Now I was taking questions for clarity.
No, Chair. Then if it's for questions, I know. I'll wait here, Chair. I'll wait for input.
Okay.
Thank you very much.
The DA, any questions for clarity?
Thank you, Chair. No, we're grateful for the presentations made and for the work done, and we have no question.
Thank you so much. The EFF.
Thank you, Chair. The evidentiary overview, is it final? And if it is final, when we are deliberating on it, and if it's not final and we are still going to deliberate on it, who is going to do the amendments to it? So I need that clarity, or we just say this is what we got from the evidence leaders, but it's missing X, Y, Z, E, and that must be included in our preliminary report, committee report. So I don't understand how we're going to join this. Are the evidence leaders still on standby where we say, no, but you didn't address this matter in the evidence, it's been left out, and we can have proof either via all the transcripts are available and also our recording. What is also missing here, President, I'm calling you President Chair, is the fact that the responses, so I know as the EFF, we had submitted a lot of written questions to various departments via the committee following witnesses' input, and they had responded. So that's also not captured in there, where we seek clarity from different ministers on various issues. So where does that fit in? Because I don't see it part of the evidence, the evidentiary overview. So if I can get clarity on how this overview ties into whether it's final and we are allowed to add whatever it is. I mean, obviously we are, but how do we go into our final report, right? And then there's something that's missing, and we're saying that this is the document that we're using as the basis of our report, but there's something missing in there, that it's clear, it's in the transcript, it's on record, we have a written response, but it's not in there. So I would think that the evidentiary overview is like a consistent work in when we're going through our deliberations, because we're also going to be going through our notes, and we will be picking up, oh no, that is what happened. If we have a once-off discussion it outside our report, I think we're still opening ourselves up to misinformation. So we can just get clarity on that. Thank you, Chair.
Yes, thank you so much. Can we get the responses?
Chair, the long and short of it, Chair, is that all these documents that are serving before you, Chair, when I say you, I'm saying the committee. I mean, the committee can effect changes to them, Chair. I mean, that's why even the evidential overview from council is still watermarked final draft. So that's a committee document, Chair, and of course it's in draft format. And if, as long as there's unanimity, in fact, not unanimity, some consensus amongst the members of the committee, and of course that has to be evidence-based. In other words, I mean, Chair, we know what findings are. I mean, findings are factual, objective discoveries. I mean, made during an inquiry. So as long as when the amendments or changes, I mean, are effected, that's based, Chair, on something that can be verifiable. For instance, what does the transcript say, and this and that and so on. So Honorable Matthias is correct. Those changes can be made. Thanks, Chairperson.
Chair?
Honorable Matthias, you have asked questions. Do you have
Yes.
follow-up?
Yeah, so are the evidence leaders still going to be part of it? So is it going to be our tech team as Parliament that will be affecting any changes to the evidentiary overview, or it will be them?
We are going to invite them when we deal with that part from tomorrow. They will be in the meeting, whatever concerns that honorable members have on the assessment that they would have presented before you. Remember, once their report is considered, it becomes your report. So that's why if there are any observations, like I said, that you want to make on the report that they have circulated with us, you note everything. When your time comes, we give you an opportunity to make your observations on the report of the evidence leaders. They will take notes, and at some point they will be given an opportunity to respond or to acknowledge all the inputs and recommendations that members would have made, or to clarify questions that would have been raised. Any further questions?
Thanks. Thank you, Chair.
Okay. Are you satisfied?
Never satisfied, but accepted.
Thank you so much. Honorable Mngango, if you would have joined the meeting. Honorable Sols.
I'm covered, Chair. Thank you.
Thank you so much. And welcome, Honorable Vessels.
Thank you, Chairperson. Let me firstly welcome the presentations made. I think it's informative and acts as good guidance for us going forth. I have no questions for clarity. I think it's very clear. I would caution that we shouldn't make things more complicated than it is. We have one report that's going to serve before the National Assembly that's going to make findings and recommendations. And the evidentiary overview is guiding in nature. It guides us with regards to the inferences made by the evidence leaders. It's not for us to accept or change it. It's for us to say, let's use it and put it in our report, or reject it and not put it in our report. But it's one report that is going to serve, and let's not overcomplicate things. That's already very complicated. Thank you, Chair.
Okay. Thank you so much for that input. Honorable James.
Chairperson, Honorable James is on the platform, but she has indicated in our group that she will not be giving any input because she's busy with another engagement.
Okay, thank you so much. We are done with the first lap of questions for clarity. We are now on the second lap, where if there are members who want to make comments, I'm now opening for you to make comments. I'm starting with the African National Congress. Not comments on matters which are still coming tomorrow or next week, but comments on what was presented yesterday. The ANC.
Thank you, Chair. On what was presented today, I'm assuming you mean. No, I don't think we
Today,
no, I don't think we don't have much, Chair. I think we share the view that was expressed by Mr. Tekene is in his presentation in terms of the roles of Parliament. We had adopted the terms of reference, which were quite clear, how certain things would be processed. I'm sure the Chair will remember, even when we're discussing the terms of reference, where we were trying to, or at least we belabored the point of the extent to which Parliament has got legislative authority on investigations. I think the guidance that is given, spelling out the doctrine of separation of powers and wanting to be nuanced in understanding oversight and accountability resonates with us, Chair. On the second report that was presented by Ms. Van Zyl Hoos, in fact, there were two reports. Yeah, we take those as really, just framing the committee report, or at least the draft committee report. So we have nothing further to add, Chair. I think a lot of the issues will be in the deliberations as we go forward. But I repeat, it's a workshop, so we don't practice dictatorship in a workshop. I'm not sure if Comrade Mdumiseni want to add. I think Comrade Sokanyila is here as well. Thank you, Chair.
Okay.
Honorable, sorry.
Yes, thank you so much for the self-correction, appropriately addressed as honorable members. Is there any one of them who may want to comment? Honorable Ntuli, Honorable Ngola, Honorable Sokanyila.
No, Chair.
Thank you so much. The MKP.
Thank you, Chair. Honorable Shongwe. I think most of what I want to speak about will come tomorrow, Chair. So
Thank
I'll
you
just hold it here. Thank you.
Thank you so much. The DA.
Chair? No, Chair. You must give us a chance like you did with the first, with the ANC, with Mkhwanazi as well. You must ask whether there's other people, Chair. I just wanted to say as well, on record, to say what you said and what I said earlier, that most of the matters will be dealt with tomorrow. That as well has handicapped me a bit to say what I wanted to say. But indeed, there's co-consent, Chair, big co-consent over this report, and that will be deliberated tomorrow. Thank you, Chair.
Okay, and thank you so much for reminding me that I must recognize you, because I had thought you exhausted everything in the previous left, but you are justified, honorable member, for you to speak in this meeting. Every member has a right to speak in this meeting, and there must never at any stage be a member who leaves this meeting with the feeling that they have not been given an adequate opportunity to speak. The DA.
Thank you, Chair. We have no inputs. Everything's very clear to us. Thank you.
All of you, Honorable Breitenbach, the DA speaks in one voice. Can I confirm
The
that?
speak in one voice, Chair.
Thank you so much. The EFF?
Thank you, Chair. Yeah, we note that this is a workshop. We might not necessarily agree with all the points that were raised in there, but it was a workshop and it was a guide, and whatever issues that we might not agree with in terms of how we go about our findings and etc. Those are things obviously we will discuss during our deliberations. Thank you, Chair. But thank you, and we do appreciate the guide that we were given. It helps us tremendously. Thank you, Chair.
Thank you so much. Honorable Mnango. Honorable Sols. If you have any comments to make, Honorable Sols. Honorable Vessels.
No, thank you, Chairperson. Let me just once again thank the team for the work that they have done. And we have no further comments. I think it's very clear, and let's get to the work tomorrow. Thank you, Chair.
Honorable James Bonani, you said that she may not be able to participate.
That's correct, Chairperson.
But for the purpose of the record of the meeting, we must call her, and for the Republic to hear that her name was called, an opportunity was given for her to speak. But because there is an apology which was served in the meeting, she is not able to speak. Okay, thank you so much, honorable members.
Chair, sorry, I got disconnected there.
Yes, we wanted to check with you, Honorable Sols, if you have any comments. Remember the first lap when we circulated, we wanted to check if members had questions for clarity. Now we want to check if you have any comments on the matters that served before the committee this evening.
Oh, no, I'm looking forward to tomorrow, Chair. Thank you.
Okay. Okay. Ms. Van Zyl-Hoos and Mr. Tejana, once again, before I call the meeting off, what are the members going to do tomorrow so that each and every member, when they leave here with one understanding what are the expectations on our part, those of us who are coordinating this meeting. When members come here tomorrow, they must come here understanding that we are going to consider the report of the evidence leaders, and they are going to be given an opportunity to make their own observations on that report. Am I correct?
And Chair, thank you very much. From my side, that is the correct understanding. The committee as a whole must just start to engage with the evidence.
Okay, and then how many days are we allocating the members to make observations on the report of the evidence leaders?
Chair, I think the schedule is stating that the real engagement on the evidence, whether it is correctly captured and is for tomorrow and Friday. However, it is an opportunity to start deliberating on the evidence and what it is showing the committee, because ultimately the committee will make the assessment.
Yes, I wanted us to establish that understanding so that if we don't exhaust the list tomorrow, members must come here and leave tomorrow understanding that those who will not have spoken tomorrow, they will have an opportunity on Friday. But furthermore, even those that may decide that they want to make written submissions, they can as well do so. For instance, if a member feels that their observations are too long, they can just do some kind of a PowerPoint presentation and say, the same way we dealt with the terms of reference. If you remember, there was at a point when members will come to the meeting and make inputs and say, look, we will make written submissions. And that worked better for all of us. And I hope that, honorable members, you have this understanding of what we are going to do tomorrow. So I want to check if there is any one of you who has a question about tomorrow and Friday's proceedings. Honorable Sangoni.
Thank you very much, Chairperson. Chair, I had raised my hand and lowered it because I thought you were addressing what I wanted to ask. The African National Congress has prepared our own report, having assessed both the preliminary committee report as well as the evidence leaders report. And within that, we have made specific recommendations, our own analysis. Now, when you started speaking about submissions, I thought that you would indicate to us if that report can be submitted by when, as well as how it would be handled. I'm assuming that the expectation you would have is that we would contribute to the deliberations based on our report, but we would like to submit a written record of all our positions, Chair. If you can guide us on how we go about doing that. Thank you very much.
Thank you so much, Ms. Van Zyl.
Yes, Chair, thank you very much. I think that will be very helpful in a way to start dealing with it, and we will welcome the submission from the ANC. Thanks, Chair.
Thank you so much. So, Honorable Sangoni, tomorrow you will come to the meeting and then officially make your submission. When we say officially make your submission, we don't mean that you can't submit any time from now. You can still submit, but you will still be given an opportunity tomorrow if there are 1, 2, 3, or 4 points that you want to talk to in your submission. And when all members have made submissions, I think we should then agree on the way forward on how those submissions are going to be considered. Am I still having another member who wants to speak?
Thank you, Chair. I think you asked a question, and I guess that the response was that it will be helpful by the legal personnel, who said that it will be helpful for us to, even if you want to send the report on our own analysis, we can do that. Though there's no deadline, which means we can send it, as you said, today or tomorrow or Friday in the morning, but we will definitely do that too. Thank you, Chair.
Thank you so much. Any speaker from the DA on this matter? The EFF? The PA?
Covered, Chair, thanks.
Freedom Front Plus?
No, we're fine. Thank you, Chair.
IFP? Action SA? Okay, thank you so much, honorable members. We have come to the end of tonight's engagements. Let me thank the content team and our legal team for their professionalism for the beautiful presentations that have been made here. But I also want to thank you, the content team and the legal team, for your resilience. We are at a moment where we begin to see the sunrises. All of us, there is a ray of light that is coming out. We now see the road where we are going, and we want to thank you so much for your support, for your patience. When members ask you questions, you never get agitated or emotional. You always keep your professional cool and respond to the questions in a very adequate and comprehensive manner. We want to thank you so much for the work that you have done for the community. And we hope that we're at a point where we can continue to step together to the final end. Thank you so much. The meeting stays adjourned until we meet tomorrow, 17 hours.
Thank you, Chair.